Every day in the USA, people find themselves in court.
All right. We're on the record. Good morning once again, Mr. Taylor. I'm going to call your case. This is file 18179FY and 1810OT. The whole traffic case is gone. This is just a felony case. The original charges were in the village of White Pigeon in 2018. As alleged at that time, you did possess a controlled substance, psilocybin mushrooms. That is a felony punishable by up to 4 years imprisonment and a fine of up to $25,000. You're also charged with delivery or possession of marijuana with intent to deliver, which is a felony punishable by up to 4 years imprisonment. You're also charged with carrying a concealed weapon, a rifle, in your Jeep Compass. That's a felony punishable by up to 5 years in prison and a fine of up to $25,000. Fourth count is possession of a firearm during the commission of a felony, which carries a mandatory minimum 2-year prison sentence preceding and consecutive to any other sentence. Your attorney, Sarissa Montag, is here with me at the court. She just had a conference with you via the breakout room. She met with the current prosecuting attorney, David Marvin. This was originally authorized during the term of John McDonough. Mr. Marvin has agreed to dismiss all of the charges, including the felony firearm mandatory prison case, if you plead guilty to unlawful use of psilocybin mushrooms. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $2,000. All the other charges would be dismissed. They're also recommending a sentence of time served. I went through your record. I believe you have 13 days since you got back to Michigan. You had 1 day at the front end, then you absconded. They picked you up. You did 4 days, then you absconded again. So I believe the total amount of credit is 17 days. So the prosecutor's recommendation is that if you plead to that misdemeanor, that'll dismiss everything else. And they recommend that you get 17 days time served. That doesn't include the time you did in Indiana. That's just the St. Joe County time. Do you understand the plea offer?
Yes, sir.
Ms. Montag, you confirm it?
I do, Your Honor. I will also state for the record that I did speak with Mr. Taylor and I did tell him that Your Honor would be going along with that plea offer. So, and I also kind of explained it to him more as like a sentence agreement, but he believes he's entering into this plea believing that he's going to get time served, credit for time served, and he'll be eligible to be released today.
And I did represent that. You understand?
Yes, sir. Thank you.
Other than this plea agreement, did anybody promise you anything to get you to plead to this?
No, sir.
Or threaten you?
No, sir.
Do you understand that by pleading to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent if and unless the state was able to prove your guilt beyond a reasonable doubt. You've been through several attorneys. First was Attorney Reed, then Attorney Truckee, and now you've retained Attorney Montag. So that was your right to hire a lawyer. All right, this is way back in January of 2018, a little more than 6 years ago, just short of 6.5 years ago. Were you in White Pigeon and had you used or possessed some psilocybin mushrooms?
Yes, sir.
Where did you get them?
I got them in Indiana at the bar.
And I hadn't seen you for a long time. As I indicated, you got arrested on January 17th. That's 2 days. You bonded on January 19th. And then you didn't show up for court, so issued a bench warrant. And then you got picked up. The bond, that back in the day, the bonding company used to go get you. Well, the bonding company went and got you on May 12th. And they brought you back to Michigan on May 14th. And you bonded on May 17th. That's 5 days. We actually got 7 days credit. And then you promptly absconded again on a $25,000 cash or surety bond. And I don't know why they posted your bond after you didn't appear the first time, but we forfeited that bond, $25,000 from quick bail bonds. And we forfeited it on September 7th of 2023. And they have a year to redeem it. I was hopeful that they would look for you, but they didn't. Anyway, they're going to get their $25,000 back because you got picked up within a year of when we forfeited that bond. But I had reopened this warrant a couple of times. I done an internet search to see where you were. I asked them to redo the warrant. We did the bond forfeiture. I thought the bonding company would go get you rather than forfeit $25,000, but apparently they didn't. So where have you been for the last 6 years?
I was in Indiana.
You lived in Peru. Were you there the whole time?
I was right where they picked me up the first time, sir.
Your Honor, can I say one more thing about the plea agreement?
Yes.
There's also an agreement, and Mr. Taylor, I didn't tell you this part, but I don't think it's a problem. Let me know if it is, that he would forfeit the weapon that was taken back in 2018.
Yes.
Yeah, that's no problem. Just, of course.
Now you got picked up in Indiana this year, 2024. Are those charges done?
No, I bonded on those charges. I have to go back to court 26th of July.
All right.
He posted that on, Your Honor, so that he could be brought here to deal with this case.
That's what he told me. What county is that?
That's Bolton County, sir.
All right, Mr. Taylor, you got 2 days the first time, 5 days the second time, and 13 days this time. So by my calculation, that's 20 days jail. 20 days jail credit, 20 days. I have to assign the minimum fine of $125 for 2 additional days. That's a $50 state minimum fee and a $75 crime victims' rights fee. Somebody bring you $125, you get out today. Otherwise, you got to do 2 more days because I'm not chasing you for any money anymore.
Yes, sir.
Go ahead.
I just wanted to apologize to the court.
Well, you were a hard charger, as my old probation officer, Bob Sabatini, used to say. And you were running faster than your feet would go. And sometimes that leads to falling down. The good news is that you're done here. This case is resolved. There's no felony firearm. You can go back to Indiana and deal with your charges there. So good luck, Mr. Taylor. I probably won't see you again. That's probably okay with you.
Thank you.
All right, good luck.
Thank you, Judge.
All right, that resolves that, and it finishes our morning. I've got to deal with a mental health case.
Thank you very
Just a
much.
misdemeanor. All right, he can go back and live happily ever after.
I will go let Judge Patterson know that you did it and you're done.
He would have had a harder time calculating that time served. All right,
Thanks,
thanks.
Judge. See you soon.
Okay. Good afternoon, sir. Are you James Charles Jude?
Yeah,
Mr. Jude, you're set for a preliminary examination this afternoon on a charge of home invasion, 3rd degree, and malicious destruction of personal property over 200 but less than 1,000. It's alleged that on or about May 15, 2024, that you did break and enter into a home at Hiawatha Drive in Sherman Township. You also did damage to the window or other property at the house. You were arrested on this charge. You were arraigned, and the matter was set for a pre-exam conference. That was last Tuesday. Rhonda Ives was appointed to represent you, and she's here today. Also present is prosecuting attorney David Marvin. When we were here last Tuesday, we didn't get very far. As I understand it, you didn't wish to speak to Ms. Ives, and we didn't get very far, so we simply said we would schedule the matter for a preliminary examination. And that was set for today at 1 o'clock. A preliminary examination is a hearing where it must be established there's probable cause to believe a crime was committed and probable cause that you did it. I met with Mr. Marvin and your lawyer, Ms. Ives, in chambers, and he was trying to fashion some sort of a disposition in the interest of the public good, I'll say. And then both lawyers went back to talk to you in the lockup. And as I understand it, again today, Mr. Jude, you don't really wish to communicate with your lawyer, and so they weren't able to even get started as to anything. Mr. Marvin, what's your position here?
Your Honor, I believe that in talking with him, that he does not understand or appreciate the nature of the charges against him. And I don't think, from my opinion, that he could effectively assist in his own defense. I don't think it would be right to continue to pursue this without some kind of a competency. I don't say that very often. I usually advocate against it. But in this case, I do believe that it would be unfair.
Ms. Ives, what's your position?
Thank you, Your Honor. Well, I will clearly state that he is either unwilling or not able to assist in his defense. He has made some statements that to me are not rational, including the fact that the victim, Mr. Jude, who supposedly is either his adopted father or father, is not his father at all. So I have serious concerns about his competency and his ability to assist in his defense, specifically stating that he has not, when we try to talk about defenses, he doesn't want to offer any information. So it puts me in a quandary, Your Honor, and I would respectfully ask the court to refer the matter for a competency evaluation.
You agree, Mr. Marvin?
Yes.
All right, Mr. Today, in order to defend you, there has to be some communication between you and your attorney. Ms. Ives is an experienced attorney. She's been practicing probably 20 years or more in Branch County here in St. Joe County. And she was unable to really establish any communication to discuss your case. So they're requesting that I ask to have you examined at the Center for Forensic Psychiatry for your competence.
No, I'm good on that.
Competence means that you
I
are,
shouldn't even be here.
what's that?
I shouldn't even be here.
Well,
You have nothing on me.
well, it isn't me. I didn't make the charge. Somebody else filed the charge. The police submitted a report to the
I should be
prosecutor. The
locked up
prosecutor.
for false claims.
All right. So that's your opinion. The whole thing is false and you don't really want to discuss it.
What's there to talk about? I shouldn't be here.
All right. We are here. So I can't wave my magic wand and make this go away. And both counsel are asking me to have you evaluated for competency.
I'm not answering no question.
All right. You don't have to. I don't know whether you're just unwilling to cooperate or unable to or both. But as a result of that, they can't even start to mount any defense. This is going to take months. You're going to be in custody pending this evaluation from the Center for Forensic Psychiatry. And Mr. Marvin indicates he usually tries to avoid it for the very reason that it takes so long to get it done. But your attitude is what it is, so I'm ordering that you shall undergo a
I
psychiatric
got the right to
evaluation.
remain silent. That's what I'm doing,
Yeah, all right, and you do.
which I've never been read my rights. Not
Um,
once.
All right, that's another misunderstanding. They only need to read you your rights if they want to ask you questions and use your statements against you. They don't have to read you your rights to
What do
arrest
you got
you, or
against? me?
put you into custody.
Nothing.
All right, your answer is nothing, and I'm gonna
What do you got?
have you examined at the Center for Forensic Psychiatry. I'm not having any more success than anybody else did, so you can go to the court officer. Your bond will remain in the amount of $20,000 cash assured. Take me back so I can go to sleep. Apparently he's quite worried about it. Anyway, this may take a while. I've signed the order and we'll see that it gets processed. Thank you both.
Thank you.